Добрий день, я вітаю всіх.
Good afternoon. I want to thank everybody who joins us. My name is Ola Atamanova, and it's my pleasure to see everybody who joins us in the Ukrainian Media Center Forum today. Today we have invited you for a presentation of the study called The Interference of Privacy under Martial Law, and today we will have the presentation of this analytical study prepared by the experts of the Ukrainian Helsinki Human Rights Union, the analysis of legislation under martial law and artificial intelligence and limitations for the privacy in the context of national security and defense. So today we'll be talking with the experts about the logical nature of those restrictions and why some of them are reasonable. So let me introduce the speakers. Joining us today are Maksym Scherbatiuk, Program Director of the Ukrainian Helsinki Human Rights Union. Also joining us is Yevhen Krapyvin, Criminal Justice Expert at the Center of Policy and Legal Reforms, and Yuliia, a lawyer at the Ukrainian Helsinki Human Rights Union Strategic Litigation Center. So, Mr. Maksym, let's start this conversation with you. So, to what extent the martial law influenced all of the processes? What have you been able to study, and what are the conclusions that you were able to draw? Well, good afternoon, everybody. First of all, I would like to say that the right to privacy during the martial law gains additional value. We had a lot of examples when we were witnessing our personal data as they were ending up in the wrong hands, as they started working against us, creating threats against human lives and health, when the personal details of the military volunteers, human rights people get in the hands of the occupiers in occupied territories. It results in a lot of problems, including problems related to the threats of life and health to those people. This is why we started working on a number of analytical materials related to the protection of personal data, possible restrictions, and what people should do generally to orient themselves in that space. Because basically there's a lot of milestones that are lost during the as the situation changes, and the martial law conditions put us in a less ordinary situation when we understand that there might be restrictions imposed. But what kind of restrictions that could be? They could be small restrictions, bigger restrictions related to one or another right. To what extent the investigation of the war crimes should interfere with the right to privacy? Or, for example, the video surveillance, like all those different aspects, they are important for understanding of all those red lines. Which are the red lines that cannot be crossed, given the approaches that the humanity has developed during the time of different wars and other crises. And us having guided ourselves with that experience, we decided to segregate some specific challenges that Ukraine is facing. And today, in fact, there will be two big works. First aspect is something related to more of a broad framework of right to privacy, and another aspect which is also of concern to a lot of people is the matter of use of artificial intelligence in the military context. The topic is quite difficult, and it is important to see some benchmarks on which we could rely upon. Also, I would like to say that Ukrainian Helsinki group has a resource, the web resource, the website called Privacy UA, where we cover these and other important topics in small analytical materials, small articles, and I encourage everybody to use those materials because they provide a broader framework and they can assist or support people in orienting what they should do, how to dispute your rights, what to do to make sure your rights are protected, and it serves as a huge aid in this area. And before I pass the floor to our experts, I would like to also thank the International Vedrodina Foundation for the support that they provided this initiative for a long time and for whom this topic is one of the key ones. Not so many institutions understand this problem, so this is why I would like to thank once again to International Vedrodina Foundation. Thank you. So, Mr. Yevhen, has the interference of privacy intensified during martial law? Do you document those red lines? Good afternoon, everybody. Let me start with the classic phrase that analytics will be available in the public domain. Everything is mentioned there. Those are small documents, so if you want, you can quickly look through them and find some key points there. But let me give you a brief explanation of what is it about. First of all, the restriction of human rights results in quite a painful reaction on part of the society. And one of the biggest examples, one of the brightest examples today, just recently, Ukraine has renewed its derogation on the European Convention on the Human Rights, in fact reducing this number of restrictions that was mentioned in the previous notification that was made during the first days of March 2022 after the beginning of the full-scale invasion of the Russian forces. But as long as this context was not communicated or the journalists worked too quickly, having cited the broad range of restrictions, the society got an impression that it's the new way of restrictions, that it's the era of authoritarianism coming. So those were the comments we could read online. For us as legal experts, it was surprising because if you really explain the context, it would not result in such an impression, because it's quite normal that the martial law conditions contemplate that certain extraordinary circumstances may be imposed which are different from normal procedures. And as the Constitution contemplates relevant restrictions, in the same way that there is a law on martial law that contains the list of restrictions of human rights that can be imposed during the martial law. And the order of the president on the imposition of the martial law and its continuation, they all contain those lists of restrictions, including restriction of privacy that we're discussing now. They're all coordinated with Constitution. They are all in accord with the Convention on Protection of Rights and Freedoms of People's Rights and Freedoms. And Ukraine entered into a derogation. We withdrawn on a timely basis from on a periodic basis from the rights and freedoms protected by this convention. But again, we're talking about the human rights in the context of the so-called vertical concept, when the government has undertaken certain obligations and they defend those rights, and it's only the government who can violate, the state who can violate it. And we're not talking about the cases when people violate each other's right to privacy, and rushing a little bit ahead, if we look through the court register and the practice of suing under Article 182 of the Criminal Code of Ukraine the violation of private life, all of the cases there, they are related to interpersonal relations between the people, like husband and wife, lovers who spread each other's personal data, inflicting harm on the decency of people. And only there are single cases when the people were suing the state for the violation of their private life by its representatives. This is why we set a task for us to understand the list of those restrictions. To what extent is it critical? To what extent is it sensitive for the population, to the citizens? And the answer is neutral. We don't have enough data to talk about some drastic cases of violation, but there are some aspects we should pay attention to. We've divided those aspects in three parts. First, it's a criminal process. It's the most invasive, the strongest legal procedure during which the rights and freedoms of the people are restricted. And here we're talking about searches, temporary access to the belongings, the forced biological sampling, and another aspect is the police activities exercised not only by police but other representatives of the government. For example, under the martial law, those the personnel serving at the block posts, including the representatives of voluntary formation of the territorial communities, which are not the government body, but they have some delegated authorities according to the law on national resistance. And the third aspect is the tendency which is the most visible within the last couple of years, everything related to public video surveillance and the way Ukraine not only guesses but repeats the errors or follows the existing trends a little bit belatedly, when in Europe and in the United States this system grows uncontrollably, thus excessively restricting the rights and freedoms of the citizens. Well, I don't have a presentation, so I'm not going to tire you with figures or detailed descriptions, but let me list the problems in all those blocks. Well, talking about the criminal proceedings, as you remember, in spring 2022, there was quite an active work in the parliament in terms of legislative regulation. And talking about criminal code, a lot of amendments were adopted within the first month, and their quality respectively is being still criticized. Some of them were vetoed by the president of Ukraine immediately, some of them were changed afterwards. And in year 23, everything related to the term of detention that was extended from 72 hours up to several weeks, those amendments were made to that article a number of times, but then it was brought into compliance with the Constitution, Article 29, which says that it's only 72 hours even during the martial law, because not all of the rights and freedoms of people can be restricted during the martial law, because Constitution contains quite a strict regulation about emergencies. In the general theory of human rights, there are two rights that cannot be restricted: the protection of slavery and protection of torture. Other rights, including rights to life, so military duty, it obviously contemplates that right to life is put under risk and it's a legitimate restriction. But in Ukrainian constitution there is a broader list of restrictions, and the reasons for detention can be expanded, but the term of detention cannot be extended. So again, there were amendments to the article of criminal code that contemplates certain exceptions from the rules, specific procedures related to the martial law, and the total goal of this article is to ensure the integrity of the justice, including pre-court investigation, if in case of any conditions, under any conditions, the territory ends up in a gray zone, or for example there are no 3 judges to consider a case. So it was quite actual during the first days of the full-scale invasion, and now it still remains present for the regions along the front lines and along the borders, because there frequently the changes are happening to the judges, to their location, and those changes, they contemplate specific standards when the prosecutor can undertake the functions of the pre-court judge, pre-court investigation judge. I've mentioned that searches, for example, the searches are filed by the investigative judge. Also talking about the detention and custody, based on the general rules, the investigator prepares the report, then he goes to the investigative judge. They consider the matter of intrusion of privacy, and talking about the search, there is a different procedure, there is a post control, but eventually when there is no investigative judge in that territory, or if they cannot exercise their function due to certain circumstances, this function can be undertaken by the prosecutor. But again, it was only effective during the first weeks or month of the full-scale invasion, because the jurisdiction could not be identified due to the quick change of the territories under and not under Ukrainian control. Now the standard is dead, but it's still used by the prosecutors in order to conduct some illegal actions. There is a practice by the disciplinary committee of the prosecutor's office, who bring them to liability for such activities when the court operates 24/7. There is an investigative judge on duty, but the prosecutor writes the report that there is no way to establish justice, and they conduct searches, seizing documents and arresting the property. It's not in compliance with the legal practice, with the purpose of this article, why it was actually amended. All those activities, they do exist, but they are in violation of privacy. But those are single cases that the prosecutor's office, using their disciplinary commission, they can cope with. But at the same time, it's certain risk. It poses certain risk, because as long as the martial law is in effect, those regulations can still be used. This is why such restrictions, they still exist, and they should be kept track of. And as a recommendation, it's not only about the right to privacy, it's about all of the cases of undertaking this function by the prosecutor. We need the prosecutor office to publish information about such cases. Again, those are single cases that can be communicated to the society, like, yes, this case has happened. And if people were not familiar with the legal procedure, they had no advocate to protect them, through the public mechanism, their rights and freedoms still can be protected. But talking about the police activities, we know there are block posts, and on top of the block posts there are expanded authorities in terms of some checks, like check of the phones in the railway stations or places of mass concentration of citizens, like stopping citizens in block posts or beyond block posts to verify their personal details. And it does not constitute any broader list of reasons for such a short-term detention or superficial inspection, like a preventive measure that is not being understood by all of the experts, because the law says one thing, the Supreme Court tries to construe it in a different way, but basically it all boils down is when people demonstrate what they have in the trunk of their car or in their backpack, in their pockets without tactile contact by the policeman. So they're not being searched, they just demonstrate, because in order to have it conducted by the police, they should have the court sanctions for that, or at least a note of suspicion. So on top of this demonstration, when the police want to inspect the contents of the trunk or of the backpack in case they identify some devices such as smartphone, which is protected by the logic protection, I mean the password or biometric protection, the person is being usually asked to unblock it, demonstrate the contents of Telegram whom they contact. So all those authorizations are contemplated by the law on martial law and procedure imposed by the Cabinet of Ministers. But again, it's a sharp edge between something that persons provide for inspection voluntarily, and when people do not want to demonstrate some pieces of their or some parts of their personal life, but they are forced to do this in front of the police. But again, under martial law, to prevent the collaboration activities, the sabotage activities, to prevent the activities of the characters calling for fire, it's all reasonable and logical. But from the point of view of privacy intrusion, you know, it raises a lot of questions. Because now it's justified by some noble goal, but again, as a recommendation, it's a general recommendation that even existed before the martial law. In the Western world, specifically in America, there are so-called standard operating procedures, the algorithms that define very standardized activities, such as related to the detention, inspection of ID, inspection of contents of the backpacks, trucks, and detention like criminal proceedings and so on and so forth. In 2016, there were attempts to implement SOPs in Ukrainian police, but it did not yield any positive results. But when person complained that their right to privacy was violated, the police said that this issue is not quite regulated. There are some trainings that they underwent that prescribe them to do so. But again, if there are standardized procedures, it does not undermine the efficiency of this process. It will be of better efficiency to both policemen and the civilians, you know, who complained the policemen to be like werewolves, wearing insignia, and so on and so forth. And it may also result in unjustified and unreasonable accusations that may result in illegal liability borne by the police. And a third aspect, the surveillance cameras. There are different programs. Those are usually the initiatives of the local governments that are called Safe City, and now they are called in a different way. But the essence is that the residents of certain community to have better track of the life of citizens, try to put those CCTV cameras everywhere. Before the full-scale invasion, it was of concern to the human rights persons and people who are concerned with the right to privacy, because the cameras collect information about everything going on around. So under the martial law, those cameras became of interest to the security service of Ukraine, because there are cameras that broadcast some place's life, and the aggressor used them to correct the strikes on some facilities or some spots, or those cameras can be seized or stolen because they physically located at some private facilities and then further on used for correction of strikes and planning of attacks. And what the security service paid attention to, they stopped the operation of those online cameras. But again, there are still issues related to the fact that a lot of those cameras, they use the cheapest proposals on the market that contemplate the existence of a Chinese manufactured software or the software of Chinese origin. And there is a number of studies, both Ukrainian and foreign, that demonstrate that those data are being transferred to the servers using different communication means, and they can be sent to the manufacturer's servers, and thus having their own camera for use for their own use, that data can be handed over to the third people. And that's exactly the reason the national police started saying that it's a problem. For example, the police is currently implementing the custody record that contemplates the documenting of activities of the detained persons, and it includes the video surveillance. And the plan is to procure a lot of cameras for different sections, because previously they contained some unreliable software. But again, I'm talking about some spheres where a state can be responsible, somewhere it's the local governments that integrate the cameras to the system. You know, legal regulation here is quite weak. There is no law that would straightforward regulate this. The Ministry of Infrastructure started expanding this safe media space. But again, this draft law that they've developed, it contains more threats to the right to privacy, because the government itself, the police, first of all, gets access, in fact, to all of the data collected from the cameras without identification of the proper user, like from the lowest rank all the way up to the top level commander, who can get access to those cameras. And again, it contains certain risks that such data can be used in improper way for some clandestine surveillance of movement of some person, which is beyond the procedure which is called the investigation activity. And on top of that, the growth of number of these cameras, why I was mentioning the foreign experience, this uncontrolled stage when the cameras are being installed everywhere, it's not in compliance with the requirements of the protection of the personal data. The Western countries have already passed this phase. They have developed the procedure to get the data from those cameras with the right inquiries to remove the data from the servers. And there are also procedures involving an AI that can process the data from those cameras, and there are already cases like this in the West. My colleague can tell you more about the problems of the artificial intelligence in the context of the right to privacy. Just let me mention that during this regulation, those aspects should be regulated too, and they should be in compliance with the experience that already exists. And the last thing, the personal data, because personal data is the cornerstone of everything here, and Ukraine is undergoing harmonization of its legislation to IQQ monitor of EU, the privacy laws of EU. And in terms of privacy, European legislation is very well detailed. There is GDPR, General Data Protection Regulation on the Act on Protection of Personal Data, which has no equivalent in Ukraine. In Ukraine, there is a law on protection of the personal data, but it's obsolete in a number of aspects. First of all, it's relying upon the convention of the year 93, which was updated, but again, there is a broader circle of questions on top of automized processing of personal information. So Ukraine has some drafts currently. They are all contained in the analytical survey, but again, there are negative conclusions from Ukrainian Committee for European Integration that engaged European Council who was criticizing those provisions, as well as other foreign experts who were outspoken in a negative way regarding this problem. Again, it's not only related to the martial law, because one way or another the process of Euro integration started in year 2014. It started with bringing of Ukrainian legislation in compliance with the law of EU, but we see that under the conditions of the full-scale invasion, those risks are growing, including those that the state reacted to, such as Chinese manufactured software, but there are other risks, potential risks, such as use of AI, unprotected nature of the personal data, because we know there are Russian hackers who are dangerous. They can get access to our personal data. All of the Ukrainians are happy when the Ukrainian hackers get access to some government registers of Russian Federation. But again, it only demonstrates how dangerous this field is, and the state is supposed to set the rules based on which the personal information is being collected, analyzed, and disseminated. And this problem existed even before, and it continues existing now. And good that there are no loud cases we would have been discussing today. But again, talking about responsibility, the liability for violation of privacy laws is minimal. And in the same way, the report of the Commissioner for Human Rights, he mentions the aspect of violation of privacy, but my personal conclusion is usually that there is no clear realization, there is no clear awareness of the limits of the privacy, and this is why people allow their privacy to be violated. Should we have more awareness campaign that there is criminal liability for illegal, for example, collection of personal data? Probably in that case we would have had more complaints, and we could analyze more complaints in this practice. So far it's minimal, and it's all described in the analytical note. Thank you for having me. Thank you, Mr. Yevhen. If I made just a small remark, what's important is to have the efficient mechanism for protection of personal data. When people understand that theoretically there is such an opportunity to protect your personal data. Now Ukraine is facing the situation when this mechanism just does not exist, and because of that there is no some significant motivation. When you understand, when there is no proper mechanism in place which would allow you protecting your rights, and on top of that there is no government authority that would be working actively in this area. Thank you very much, Yuliia. So let's proceed to the artificial intelligence and privacy intrusion. To what extent those notions interfere? Is it true that using AI the human rights can be violated? Thank you for this opportunity to give you more explanation about the artificial intelligence and human rights. Well, I have to emphasize that currently we're facing a lot of application of AI in our everyday lives. This is why it's no surprise that gradually the mechanisms of the artificial intelligence are implemented in the military. It's worth also mentioning that the use of AI technologies does not only violate the matter of privacy, but also other fundamental human rights and freedoms. We need to highlight it that on the national level, on international level, and supranational level, on the level of some international organizations, there are attempts to regulate the matter of AI application in general, and there are also some attempts to provide recommendations to formulate provisions on the use and application of the AI in the military. We could mention the recommendations of OECD. That was the first regulation that adopted the principles of use of the artificial intelligence. First of all, it's supposed to be used for the good of the people, for the growth of the common welfare. The systems of artificial intelligence are supposed to be safe and secure. There should be always a control on side of the operator or developer to make sure that this system is reliable. Does it contemplate a reaction to the risks that can arise in process of its functioning? Also, it's a matter of liabilities. Who's responsible for proper operation of this or that system? And the key aspect is that any artificial intelligence system is supposed to be used and should be in compliance with such principles as compliance with the democratic values, fundamental human rights, and the rule of law. Recently, the European Parliament adopted the law on artificial intelligence that will come in effect in European Union. That's the first legislation in the world that to a certain extent regulates the use of the artificial intelligence. It implements so-called horizontal approach. It's presumed that it will cover all of the industries and areas, but the matter of application of AI in the military is not covered with this regulation. This is a peculiarity of the legislative work of the European Union, but again, it proposes to divide the AI systems by risk degrees or risk grades, such as, for example, something that is used in everyday life like ChatGPT, but there are other systems that pose more risk, and there are so-called prohibited practices such as mass video surveillance in real time. And at the same time, simultaneously with the adoption of this law on AI, there was the text published by the Framework Convention of the European Council on AI, which regulates the application of AI in public sphere and private sphere. Well, the regulation in private sphere is left at the discretion of each national government. And when we talk about the application of AI in the context of national defense, well, it's not regulated and it's left at the discretion of the national governments. Again, they're supposed to use the AI systems adhering to the fundamental rules of the use of AI. And when we talk about the application of AI systems in everyday life, use of these systems may result in violation of this or those fundamental human rights. And even regardless of the advantages provided by the technology, we may say that their use might violate the freedom of speech, the freedom and the privacy. And if we talk about the use of AI in the military, it's used for repelling the armed aggression mostly, and such AI that can be used in the military, it should be in compliance with the international humanitarian law, at the same time compliant with the fundamental principles that ensure the compliance with the human rights. And if we talk about the use of AI in the military, it's important to comply with the basic principles of international humanitarian law, the principle of proportionality during attacks when we talk about the AI-equipped weapon systems, and the principles of discerning military and civilian facilities. Even during development of the new arms, the discretion of the belligerent parties is not indefinite, and it's subject to certain restrictions. For example, the attacks of mass destruction, using the mass destruction weapons, or the use of weapons that may result in excessive suffering and mass death. And when we talk about the use of AI in the military, the key problem for us is to ensure the right to life as one of the fundamental human rights. The Convention on Human Rights and the Civil Pact on Civilian Rights, they contemplate that during the emergencies there may be some restrictions imposed, and such restrictions, when we talk about them, the discretion of the government is not unlimited. Again, if we talk about right to life, there are minimal guarantees that are set forth in those conventions, and even during the martial law, during the war, the governments cannot withdraw from those provisions. And the main issues that arise in case of the use of AI, they are related to the use of autonomous weapons, the lethal autonomous weapons, the weapons that are capable of identifying the targets based on special algorithms by themselves without human input. And in this aspect, the fundamental ethical and legal question is whether the use of autonomous weapon systems is legal at all. And the main question emphasized by the international community is that the use of autonomous weapons should still be under the control of the human. So the decision to inflict the lethal damage should be undertaken by a human eventually. If we talk about development and manufacturing of new equipment, it's important to emphasize the prohibition of torture and suffering. All of such weapon systems, they should be in compliance with this prohibition. It's set forth in the international humanitarian law, and it correlates with other provisions of international humanitarian law that are set forth in all four Geneva Conventions, because all and any military capabilities, warfare capabilities, should not be used in case they inflict excessive suffering or excessive damage. And in this key is quite a contestable issue whether the AI can evaluate the level of excessive damage and excessive suffering. And here we're getting back to this issue that the control of the AI-operated weapon systems should be exercised by human operators. Also, in the context of implementation and development of AI systems, it's important to adhere to the principles of non-discrimination. This is one of the key requirements of international humanitarian law and one of the fundamental principles of implementation of AI-powered systems. And it's important to mention that in the military, AI is used to analyze and forecast targets, to identify threats, and to analyze the development of attacks, for example. And in this case, we should pay attention to the fact that the artificial intelligence system should be verified whether they comply with these principles of discrimination, whether some algorithms may result in specific bias or creation of bias, and if they create some bias, such artificial intelligence systems should be under continuous control on all phases of operation. These systems should be controlled in order to identify and prevent discrimination aspects. Getting back to the AI-powered weapons systems, we need to remember that any weapons, they should assess the proportionality of attacks, whether there will be the weapon advantage over the harm inflicted by the effect of that weapon. And again, there is a question whether AI-powered systems are capable of evaluating potential harm that would be inflicted and to forecast whether the use of such weapon systems would not result in a discriminatory attack. And the key issue that can be related to the use of artificial intelligence and use of artificial intelligence in the military is the right to privacy and right to protection of personal data. In this aspect, it's worth mentioning that the interests of national security may serve as a ground for restriction of privacy, but the discretion of the state is not unlimited. It should be governed by certain weights and balances that would make the violation of human rights impossible, and any restriction in this area is supposed to be contemplated by the law. It should pursue some legitimate purpose related to national security and defense, and it should be proportional. In the practice of European Court of Human Rights, it's emphasized that the use of the mass surveillance systems may be justified in the context of national security. But again, evaluating whether the state was acting on a legal basis, we need to verify whether the state has created weights and balances to prevent the abuses in this area. And when we talk about the surveillance systems, video surveillance systems, the face recognition technologies may also be in violation of the privacy, depending on whether there were guarantees contemplated to protect the citizens and whether the state was acting on a legal basis and whether such guarantees and mechanisms were created to protect the rights of the persons and to prevent the abuses in this field. And when we talk about the AI-powered systems, we need to also mention that it provides a lot of advantages in the military and in everyday life, but again, we are never protected from someone who can use it with malign purpose. And in this aspect, the artificial intelligence can be used for prevention of misinformation, but on the other hand, it can be used for creating misinformation, because propaganda and psyops and influence of the public opinion can be viewed all as the elements of modern armed conflicts which have hybrid nature. They don't include the use of conventional weapons, but also the information attacks and cyber attacks. This is why it's important to make sure that every artificial intelligence system is secure, and it's important to have artificial intelligence which can be used both for ensuring the cybersecurity, but on the other hand, it can be used with malign purpose for cyber attacks. So again, it's important to find this balance between ethical proper use of artificial intelligence and ensuring liability in case it will be used with malign purpose. This is why in our study we emphasize some key recommendations related to the use of artificial intelligence and the use of artificial intelligence in the military. Again, it's the liability and control and security, reliability, prohibition of use of autonomous weapons systems, protection of civilians, and some ethical reflections. I mean that the use of artificial intelligence should comply with some ethical guarantees and always be under the control of the human operators. Well, thank you, Yuliia. So the situation is such that on the level of legislation, it's not yet regulated. Artificial intelligence has a lot of risks that you've just mentioned, and there are also some risks that we may not yet know about. Some potential challenges that we are about to face, and again, we cannot even start talking about liability because at the level of legislation it's not yet implemented. Is it? Do I understand it correctly? Well, if we talk about the use of the AI in the military, yeah, obviously we don't view it as something autonomous. There is always a human operator behind the AI, and then the liability is vested in either the final user or the operator or the developer. If we check the international humanitarian law, the military command is in charge of planning, and if any attack results in violation of international humanitarian law, it may entail liability by the command who was planning this attack and who were supposed to cancel this attack in case they understand that such attack would result in unproportional results. Also, there is a liability on part of the operator who uses the weapon system to make sure they comply with international humanitarian law, to make sure that is the same type of equipment as everything else, and it has all those standards of international humanitarian law used for it. So, like, don't attack the civilian population, restrict the results of the attack so it does not result in discriminatory attacks. Thank you very much, dear colleagues. Do we have any questions or comments on the floor? Thank you. Yuliia Kadina, Ukrinform, good afternoon. I'm having two questions. Well, first of all, can you please tell us more about the study itself? How was it going? How many respondents were involved? What was the period of the study? And what exactly were you studying? The court awards or other documents? Thank you. And another question is to Mr. Yevhen. You've mentioned statistics a little bit, but like a little bit more information. During the period of your study, how many cases were initiated during the period of your study, and do you have any information about the results, about the court awards based on the results of those cases of privacy intrusion? Well, let me start. The period of study was starting from the year 22 with the beginning of the full-scale invasion. The legislation, the court awards, court resolutions were analyzed by us. We were analyzing Ukrainian legislation and the practice of European Court for Human Rights and international standards in this area. Maybe Yevhen may add something else. Well, I'm not going to quote the figures from my memory in order not to be erroneous. Well, they're all contained in the document, but again, in the report of the Commission of Human Rights, there are no figures because the Commissioner focuses more on the privacy in occupied territories or privacy of the people who left the occupied territories and were witnessing about such cases of violation. It's more of a matter of international criminal court jurisdiction. Well, what I've mentioned the criminal aspect is that there is data for the years 22, 23 and first quarter of year 24, and specifically talking about the criminal proceedings. No, there is not such a huge number. It's 164 in year 22, 422 in year 23, and 202 in the first quarter of year 24. And 23 of them were forwarded to the court in 23, and 123 in 22, and 23 in the first quarter of year 23. But again, there are resolutions that came into force. There is probably a dozen or a couple of dozens of them because it's a process extended in time. I got myself familiarized with all of those resolutions. They are all open source. There are no such that would be with some limited access, and as I've mentioned, only one of them was mentioning the fact when the policeman in violation of the law got the access to the private information or private details of civilians that was later used for the purposes of fraud. That's the one case of classic intrusion of privacy by the representatives of the state, which resulted in a liability of item 182 of the criminal code, the violation of private life. All other cases are the interpersonal relations, like a married couple, for example, or other couples, like non-married couples, that resulted in some disclosure of personal information, like nude pictures of partners, which is not actually a subject of our research because we try to see where the state interferes the way the people exercise their human rights under the procedures contemplated by the law. So as Maksym has mentioned, it's not quite the practice that we should adhere to, because there is no such liability that will, however, it does exist for the representatives of the state. There is the disciplinary liability, but again, people are not quite aware. They do not possess specific knowledge where to go, where to apply, whom to report based on the fact of the violation of your privacy. Again, this sphere is only described by the cases that are available in the public space rather than by statistics that is quite imaginary, and they do not allow us to assert that right to privacy is violated to a certain extent. Thank you very much. Dear friends, do we have any more questions? If we do not, I would like to thank our speakers for their comprehensive study, for the great job they've done, and for that analysis. Thank you very much. Thank you for your interest to this topic. We'll continue working together for our victory. Thanks everybody. See you shortly.
Запрошуємо на каву паузу.